case briefs, and so much more. LSData's got what you're looking for.
In 1994, the Montana Supreme Court heard the case of Holtman v. 4, G's Plumbing and Heating, Inc. The case dealt with the question of whether a new claim is barred by res judicata or collateral estoppel. Roger Holtman sued 4, G's Plumbing and Heating, Inc., claiming that the company negligently installed a heating system that caused asbestos contamination. Prior to this lawsuit, Holtman had brought a counterclaim against an association, which was dismissed due to procedural issues. The court initially ruled that the dismissal of Holtman's previous counterclaim barred his claims against 4, G's Plumbing. The court decided to grant summary judgment in favor of 4, G's Plumbing on that claim. Holtman then appealed. The appeals court found that the elements of res judicata and collateral estoppel were not met in this case. The court determined that 4, G's Plumbing was not a party or privy to the previous litigation involving the association, nor was the identical issue or precise question litigated in the prior action. With this ruling, the court ordered the case to be reversed and remanded for further proceedings consistent with its opinion. This decision sent the case back to the lower court for a new trial or reconsideration based on the appeals court's analysis.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.